Good morning, everybody, and welcome to this Inside Housing webinar on how EU procurement changes will affect you, kindly sponsored by Capsticks. My name's Emma Meyer, I'm the editor of Inside Housing, and I will be chairing today's session. Earlier this year, as you'll know, a new EU public sector procurement directive was adopted, and here in the UK, the government has just finished consulting on the Public Contracts Regulation 2015, which will implement that directive in the UK. EU procurement rules are often criticised for being overly complex and disjointed, and they're also blamed for causing risk aversion and disproportionate approach by contracting authorities. But the directive and the draft regulation have the potential to bring some improvements on that, and as you will hear later, there's a fair amount of good news in these changes. The government's stated intention was to give as much flexibility as possible and to prevent going beyond the requirements of the EU directive or gold plating. The deadline for implementing is the 17th of April 2016, but we're expecting that implementation to happen, in fact, in 2015. So this session is here to explore the key changes and how they'll affect you. And I'm pleased to say that we have an excellent panel with us here today to help us to navigate that topic. Justin Alford is partner in the commercial team at law firm Capsticks. He works with public and private sector in the NHS, and he specialises in commercial funding and procurement issues. Ranjit Kaur is Group Procurement Manager at Circle Housing, which has already embarked on a comprehensive plan to prepare for the changes. And Lisa Hewitt is Procurement Director at Procurement for Housing, where she's responsible for the quality assurance of all legal and regulatory requirements associated with EU procurement. So a really excellent panel. Welcome to them all. The webinar is going to work much like a face-to-face panel session would at a traditional conference or event, but with a few added benefits thrown in for good measure. So each panellist will talk us through their slides, and at the end we'll move on to a question and answer session. You can submit questions at any time. If you look on your screen at the moment, you'll see a green bar towards the top, and if you hover over that, one of the things you'll see is Q&A, and if you click on that, you should get a Q&A box appearing on your screen. You can use that box at any time when the speakers are speaking or in between times to type a question, and that will appear, and we'll all be able to see the question that you've asked. I'll be gathering together those questions after the panellists have spoken, and using that to drive our discussion session. But in addition to that, the panellists are actually able to start answering some of those questions in the text box as the presentations are continuing. You'll actually be able to download a transcript of those written questions and answers at the end, which I think will be a really useful sort of take-home thing. So now, with that housekeeping complete, it's time to get started with the presentation. First of all, I'm going to hand over to Justin, who's going to take us through the substance of the proposed changes. So without further ado, over to you, Justin.
Thanks, Emma, very much indeed, and good afternoon to you all, and thank you for joining. Thanks for the invitation to be here. My role in Capsticks is to provide a lot of advice on procurement issues, and really drives a lot of what we do, working with a number of public bodies, including a number of housing associations. And it's maybe strange for a lawyer to say it, but I'm a lawyer and I'm here with good news. So it's nice to be able to say that. There are a number of items as good news, and rather than try to work through all the bits and pieces that the new directive is introducing by way of change through the regulations that Emma has mentioned, there are just 5 things I want to hit on quite quickly, and might help to frame discussion later. I think for a number of clients I work with, and particularly in the housing association sector, people find that procurement is there as sometimes a hindrance to achieving the commercial ends that they want to reach, rather than actually helping to deliver on those. So the first thing that I've got there as a good news item is that there are going to be new options and new routes for procurement. For those of you involved in procurement on a regular basis, you'll know about the standard routes that are there, most frequently used being the open procedure, the restricted procedure, competitive dialogue. In addition to those, there are going to be new procedures for innovative projects and partnership arrangements. So the innovation partnership is something that's new, that's aimed to take forward a relationship in a phased basis and lead to projects that are complex being delivered in phases in a partnering way. That's good. There are also additional options for negotiation in competitive dialogue. So when you start to look at just the procedures, there is more flexibility there which can help. Next bullet point, I've got some good news, because one of the issues that I find clients bring to me is that as things currently stand under the regulations, we know sometimes that there are contractors out there who have got a bad track record, but we can't readily take that bad track record of poor delivery or poor engagement in a partnership way into account when we shortlist bidders, because we can only shortlist bidders on the basis of whether they've got the technical competence and whether they've got the financial strength to deliver in broad terms what's required by the procurement we're running. The good news under the new regulations is that as a contracting authority, we as housing associations are going to be able to exclude bidders that have a poor record, so have had early termination of their contracts, for example. It's a key one. And you can do that and exclude a bidder at any time during the process, and not just when you're shortlisting a bidder. Sometimes it's the case that bidders, once they get through the PQQ process, the pre-qualification questionnaire process, they think, right, okay, we're through, we're in, we're now through, and we can engage in the tender without having to worry about track record problems. Well, actually, now the good news is that contracting authorities are going to be able to consider those poor records and be able to remove people from the bidding process at any stage. So that's positive. The third thing I've got there is some good news regarding other mandatory and optional exclusion grounds for bidders. So, for example, there are provisions being built in regarding the need to remove from the bidding process bidders who have in some way had sorry, I just heard some interference on the line, but the good news is that there are grounds for removing bidders and excluding bidders in relation to human rights abuses, trafficking, fraud, withholding, not paying taxes and customs duties, etc., etc. So there are more grounds there to make sure that the people you're dealing with are effectively the sort of people that you want to be dealing with on the other side of your contracting arrangements. So I think that's good news as well. Moving on to the next couple of items. Good news at the top of that next screen, codification of Tekel and City of Hamburg. And what I mean by that is a bit of background, a bit of law. I'm a lawyer, so I'm afraid I have to talk a bit of law. There are a couple of cases that came out of the European Court of Justice that provide a structure for entities that are governed by public procurement rules to get together, to work collaboratively in partnership, and to be able to avoid having to go down a full public procurement, provided they comply with certain structuring rules about how they work together, the fact that they are fulfilling obligations and duties that are placed on them as public bodies, and that they are not spending more than 20% of the work that they're doing in that way for any private sector entity. So it's public services for public services bodies, etc. That's what it's about, and that's what these two cases are about. One, just in terms of partnering on a sort of a contractual joint venture basis, that's the City of Hamburg, also known as Commission in Germany. The other, Tekel, is about where public bodies wanted to get together and to form a corporate joint venture, and to have a joint venture company established, and that can be done without regard to having to do a full EU public procurement exercise, and you can do that following the principles that are laid down. And the good news is that these regulations that are coming into effect next year are going to clarify and crystallize exactly what you need to do in order to take advantage of these flexibilities, and thereby sidestep altogether the obligation to go out to public procurement when you're putting in place those kinds of arrangements. Finally, last bullet point there, good news regarding variation rights to allow changes down the line. One of the things that, again, I often get asked about is, well, we entered into a contract and we want to amend the terms and the conditions of the contract. Can we do that? And it's often the case now that if you're looking to enter into a variation to your arrangements that has a material change to the contract, then European public procurement law prevents you from doing that because of a case called text. The change that's going to be introduced allows you actually to make changes and variations to contracts if you build in the express right to do so at the start of the contract, and then you keep within certain limits about what it is that you want to change. But that global exclusion on material changes is going to go, which gives us more flexibility about changing the nature of our relationship with our contractor as we move through the life of a contract. So that's all good news as far as I'm concerned. That's all I wanted to contribute at the moment. So Emma, back to you. Thanks.
Thanks very much, Justin. There you have it, a lawyer with good news. I think a crucial point there being more flexibility on a number of different levels, and look forward to exploring some of that a little bit more in the Q&A session at the end. Don't forget, if you're watching live, you can submit a question using the menu at the top of the screen. Just type in your question, and we'll get through as many as we can. Somebody's asked already whether the presentation slides will be available for download as well as the Q&A. Yes, they will be available on the site after the end of the webinar. Next, I'd like to hand over to Ranjit, who's going to talk to us about the benefits of these changes, and also what Circle has done and indeed is still doing in order to prepare for that. So over to you, Ranjit.
Thank you. Hello, everyone. I'm Ranjit Kaur. I'm the Group Procurement Manager at Circle Housing. Circle Housing is one of the largest housing associations in England. We offer a wide range of housing choices for over 110 local authorities, and we have 70,000 properties across England with 300,000 customers. At Circle, we have a dedicated procurement team who are conscious and engaged with the proposed changes to the procurement regulations and are aware of the implications that they will have on us. And we've been following the communication and discussion on the new regulations from the initial draft of the regulations to consultation. We have a large dedicated procurement team, as I say, and as a team, we've had a look through the changes, and we feel that they are quite positive. We see them as being quite simplified, as Justin has also said, they're quite flexible and more clear. Some of these areas that impact on us are early market engagement, SME participation, simplifying the selection process, and more simplified approach to social and environmental criteria, which is much easier for us and suppliers to understand, e-tendering and timescales and contract changes. And at the moment, we are already started to preparing for these changes so that we can address the future requirements. In terms of market engagement, Circle has recently held a supplier day with our existing suppliers for them to come and talk to us and find out a bit more about our values, visions and plans, and also for us to get feedback from them in terms of their experiences of working with us. It's been quite useful, and we've had a lot of feedback. In terms of the regulations, I think this is a good step forward because it enhances our opportunities to better understand what our suppliers out there are experiencing, and also they've even got the opportunity of understanding what we are looking to procure in the future and what our requirements are going to be. In terms of the supplier, they are then better placed to decide if they wish to tender for opportunities. And in terms of that, the regulations have also outlined responsibility on contracting authorities to have electronic communication. And as an organisation, Circle currently doesn't have any tendering solution at the present. But however, we are working on that at the moment, and we are looking to implement a solution so that we can better engage with our suppliers before the procurement process starts, as well as obviously during it. In terms of SME participation, we are looking at reviewing our PPQ requirements with a view to standardising our approach. Obviously, the regulations are looking for us to try and reduce the use of PPQs, especially in low-value contracts. And as an organisation, we are quite open to that, and this is something that we are currently reviewing. We've also had a look at the European Single Procurement document that has been discussed. However, obviously, we still wait further information on this to see how that will impact on us and what our suppliers will be required to provide us, and to see if that's adequate for us to progress with. We currently do look at dividing opportunities into lots. That's something that's quite important for us. In terms of ensuring that SMEs get an opportunity, so that we'll continue to work with that. Another thing that we're looking at the moment is workshops for SMEs to explain how we are going to work in the future, what our requirements are, and so that we can explore future opportunities with our suppliers together, so that we can maximise their participation. We have 9 registered providers across the country, and so we are quite dispersed, and we do have a lot of local requirements. Therefore, we feel that to encourage SMEs, we need to be able to understand them at a local level. So we are looking at a possibility of workshops, local workshops, so that SMEs can come and talk to us. One of the examples of something that we're doing at the moment, we are currently revisiting a procurement strategy with a view of moving away from a single contract with a number of suppliers to a regional, multidisciplined approach to encourage local suppliers to meet the local needs. And that's something that we've done as a result of some of the recommendations that have been coming through recently. In terms of social and environmental, Circle has a mission of enhancing life chances of our residents and tenants. So we're always seeking opportunities to maximise social impact through our contracts that are awarded. We do look at training opportunities and apprenticeships. Currently, for every £1 invested through our social dividend, we return a total social value of about £12. So obviously, we envisage increasing that, and hopefully the way that the proposals are being put together, that we can work on improving that. We also are working with our green team, so we have a green team within our organisation to explore further opportunities to add benefits through our proposed contracts, so looking at environmental credentials, but obviously we're aware of the impact this may have on SMEs and service delivery, so obviously we need to make sure that there's a balance there. In terms of contract management as well, we are looking for our procurement team to take on contract management of key strategic contracts. Now, the reason being, as Justin has already explained about being able to use past performance as a way to exclude proposals, we want to make sure that we better monitor our own contracts in the first place. So if we, as a procurement team, we are looking to bring that in-house and manage those, so we can understand our suppliers and how they're performing, and obviously look to reward good contracts and good performance. supplier past performance intelligence will help us, assist us with our future tender opportunities, and then we'll be able to use the new regulations to assist us with that. We're also looking to broaden our network by working with our peers so that good suppliers are recognised within our sector. And finally, in terms of contract changes and variations, we are aware of the variation explanations that have been provided. We are working with our legal team to review our contracts and tender documents so that we can incorporate any changes that we need to in the tenders that are going out currently. But we don't want to use this new exclusion just as a way to avoid procurement. We always compete on the open market, but it is important for us to consider the options available, because this, as everyone said, does allow us a little bit of flexibility. So we are conscious of that. And thank you. Emma?
Thank you very much indeed. So lots of interesting activity going on there, accompanied with a comprehensive communication strategy as well, to make sure that that message gets out far and wide. Thank you very much indeed for that. Just a reminder on the questions, if you want to submit one, if you hover over the green bar at the top of your screen, you should get a menu that comes up. One of the things on there should be Q&A, and if you click that, you should get a separate dialogue box that comes up that allows you to type in your questions. If you don't see a Q&A box, right to the far right-hand side of that menu, you'll see a little arrow, and if you click on that arrow, the Q&A may have dropped off the side of the menu. So just click that little arrow, and you should be able to select the Q&A option there. So hopefully that helps if you're sat there, sat on your hands trying to ask a question and unable to do so. So look forward to picking up some of those questions shortly. But before we move over to the questions, of course, it's time for me to hand over to Lisa, who's going to summarise what the changes mean with some reference to procurement for housing members, and how the changes could interact with organisations' future plans as well. So next up, over to you, Lisa.
Thank you very much, Emma. I suppose my overview now actually fits nicely, as I will basically straddle what Justin and Ranjit have just discussed. I'm Lisa Hewitt, the Procurement Director for CEO Procurement, and we manage procurement for housing. For my part in this webinar, I will provide a brief overview of what the new draft regulation changes mean and any potential impacts, and then close with a brief update regarding trends which have been highlighted from some of our members. So firstly, over the next few slides, I'd like to cover the new directives that are being implemented and how they've changed the regulations, the abolition of Part A and Part B services and how this will help to deliver greater clarity where there'll be no grey area anymore, the procurement principles and how these are the fundamentals for delivering appropriate procurement undertakings, potentially how the new draft regulations will affect our members, and finally trends that have been coming through on particular issues for procurement and procurement for housing members. So firstly, the current European rules on public procurement date from 2004, and they aim to make the procedures for running and awarding public procurement contracts transparent and open. These rules are now changing in line with the publication from the European Commission dated December 2011. As a contracting authority, procurement for housing need to ensure, as do other contracting authorities, that they are actively working to ensure they are implementing and adhering to the new draft regulations. 3 new procurement directives have been published following the amendments to the regulations, and these are the Public Sector 2014/24/EU, Utility Sector 2014/25/EU, and the Concessions for both sectors 2014/23/EU. These will replace the existing Public Sector and Utilities directives, and they will add a new addition to cover the procurement works and services concessions. The new rules simplify procurement procedures and make them more flexible. Minimum deadlines for procedures will be shorter, and only the winning bidder will need to submit documentation proving that it qualifies for the contract in question. In relation to Part A and Part B services, The abolition of the different Part A and Part B services means that the distinction which is currently in place for full OJEU requirements for a Part A service and limited technical and procedural requirements for a Part B service will no longer be valid. All services will be subject to the full application of the procurement rules, including advertising OJEU and complying with standard procurement procedures, with the exception of social and health services. For social and health services, a higher threshold of €500,000 will apply to these service contracts. A contract notice will still be required, along with a contract award notice, and the other previous procedural elements of the tendering process will be limited to ensuring compliance and transparency and equal treatment. The light touch regime will apply to contracting authorities which are not classed as central government bodies. So your central government bodies are classed as your departments of health, your NHS, your ministerial departments, and those governed by their subsidiaries and local councils. For contracting authorities which fall out of these areas of central government, they will be governed by Regulation 76 of the Public Contract Regulations and will be able to set the time limit for the receipt of tenders by a mutual agreement between the authority and selected bidders. And they will be able to determine the procedures which are to be applied, but again, they must be compliant with the procurement principles. Which leads me nicely to the procurement principles. The Treaty of Rome, adopted in 1957, established the rules for the European Economic Community. The 1957 treaty, which has since been renamed the Treaty of the Functioning of the European Union, applies to member states, public authorities, and anybody which provides a public service under the control of government. The treaty does not include any provisions on public procurement. However, it does prohibit discrimination by member states on grounds of nationalities and establishes basic certain freedoms. Those that are relevant to the public sector are freedom of movement of goods, freedom to provide services, and freedom of establishment. In addition to these obvious barriers, there lies the risk of discrimination by public sector contracting authorities in favour of national and local suppliers, and the Public Sector Procurement Directive is based on certain key principles that mitigate this. These principles are transparency. Contract procedures must be transparent and contract opportunities should generally be publicised. Equal treatment and non-discrimination. You cannot discriminate on the grounds of nationality, and all potential suppliers must be treated equally and given all the same information at the same time. And proportionality. Procurement procedures and decisions must be proportionate to the undertaking at hand. So where does this leave members? This will affect members of Procurement for Housing or any other contracting authority. It shouldn't. For the fact that the contracting authority will need to adhere to the new directives and adopt the principles on behalf of the member organisations, the members should in fact see no changes to how they access contracts and frameworks. The contracting authority, acting as the facilitator of the contract or framework, will work under the guidance of the new directives and ensure they are compliant with the changes. For instance, there are differing dates as to when the new directives are looking to be implemented. The Public Sector Directive needs to be implemented and adopted by early 2015. The utility sector will be spring 2015 and the concessions will be spring 2016. The onus is on the contracting body to have this information retained and the necessary steps taken to have updated their governance procedures in relation to public procurement undertaking. So with this in mind, drivers moving forward and issues that members have brought to our attention, we've undertaken a general consensus and data gathering to determine the trends that are being highlighted. The repeated messages are that of new build and the requirements organisation have for taking on board more units along with the regeneration of existing units. Figures published in November show 700,000 more properties have been delivered since the end of 2009, with voids at a 10-year low. But still more needs to be done to meet the housing needs of the UK. The Affordable Home Programme is the main programme for new affordable housing in England, with the intention to provide 170,000 new homes during 2011 to 2015. Under the programme, which is administered by the HCA, successful bidders have secured £1.8 billion in government grants to aid the delivery of this project. The majority of new homes built under this programme will be let at an affordable rent. The second issue that has been brought to our attention is welfare reform. This is a growing issue due to the affordability of homes. The welfare system is being reformed to help more people move into and progress into work, as the government believes the current system is too complex and they want to make the benefit system fairer and more affordable. The changes to the welfare system main elements are a stronger approach to reducing fraud, creating a fairer approach to housing benefit, preventing abuse of the social fund, and reducing the number of people who are in work but still living in poverty, to name but a few of the areas the government are wishing to tackle. And then finally, the major drawback for many members is their lack of resource for their procurement teams and the difficulty in recruiting to the sector. With this in mind, it's found that some are still heavily reliant on their suppliers to provide market information. They are also having increased pressure from regulators to determine where the value for money aspects are being driven from. And this is where contracting authorities, purchasing consortiums and collaborative undertakings need to work more proactively in the market to aid delivery of relevant and pertinent procurement offerings and work more cohesively for a collaborative approach to meet the needs of members and to align to deliver legally compliant frameworks and adhere to the new directives being implemented. Thank you.
Thank you very much indeed, Lisa. I think a really useful, as you say, useful sort of summary of and linking together of the previous two presentations. We've got a number of questions coming through, and we now have about 20-25 minutes for questions. So we can turn to those in just a moment. If it's not too late, however, if you've got a burning question or comment that you want to make, then please do submit your thoughts using that question and answer dialogue box. The panel have started to answer some of those questions in the Q&A box, but now we'll turn to some good old-fashioned conversation as well. So I'm going to pick up on quite a specific but important point first. For those who haven't spotted the conversation that's going on in that Q&A box, we had a question early on about how TECL applies to Part B services. Justin, you leapt in to answer that, so perhaps I could hand over to you for a quick recap on that one.
Yeah, thanks, Emma. So the question was, well, how does TECL apply to Part B? And although I didn't mention it, Ranjit went on to talk about how Part A and Part B is being removed, as did Lisa. So the Part A, Part B distinction about whether you have to go through a full procurement route or whether there's a lighter touch regime available through what was Part B in respect of, for example, healthcare services or legal services. Those are some that went under the Part B. That Part A, Part B distinction is going. Now, in terms of TECL is helpful in that if you have a model of cooperation to establish some sort of joint venture company to fulfill your public obligations in a way that is collaborative with other housing associations or other public bodies, that meets the tests, including the test about 80% of income coming from amongst the partners and not coming from outside or from the private sector, then TECL means that you don't have to worry about a Part A and Part B, or worry about whether you have to run a full regime or you can take it through the lighter touch regime of the new social and specific services approach. TECL sort of gets you out of everything in that respect. However, if you're in a position where you're structuring it, but actually you're thinking, well, we're not really sure that we're going to be able to get 80% of the income into this joint venture company from the public bodies that are cooperating in this way, that's key as to whether you will be able to rely on the TECL exemption or not. If you're thinking, well, actually, we're only going to be getting 75, 70%, 50% of income from us as a group of partners collaborating in this way, then you need to think, well, okay, in that case, we are into a situation where we are going to have to be contemplating some sort of public procurement route. What are the options for us? If you are going to be providing services that fall within the bracket of being social and specific services, whether we have the light touch regime, then you can go ahead and you can structure through the light touch regime that's being established for that. If you're putting together a partnership where you're expecting to generate and have have effectively purchasing of less than €750,000, then that light touch regime that's in the regulations doesn't apply either. You need to comply with the Cabinet Office's requirements for running procurements and any existing standing orders, standing financial instruction, procurement governance arrangements that your organisation has. So it's a bit of a long answer, but I hope that gives some sort of indication about when you can use TechL and when actually you need to be considering the other options. If you're not in the realm of social and specific services for the collaboration, then you're thinking, well, actually, we as a group of contracting authorities need to be running a full procurement process in order to decide how we're going to provide these services through the restricted or the competitive dialogue or the competitive dialogue with negotiation type route. So, yeah, long answer, but then ask a lawyer and you like to get a long answer.
Thank you very much, Justin. Value for money there, I think. Thank you very much for that. I think a pretty comprehensive answer. With any of these questions, if you've asked the question and you want to ask a sort of a sub-point to it, then do feel free to use the question and answer box to come back and do that, and we'll try and sort of make it as much of a conversation as we can do. Next, I'm just going to move on. One for Ranjit. I think somebody asked about how you do that work, measuring your social impact, whether it's something bespoke or whether it's an off-the-shelf solution, and how it works really. Ranjit, could you perhaps give us a little bit of an insight into how you do that?
Yes, we have an in-house model, so we do have a community and development team who've been working on our model in-house, and they've developed it on. So basically it takes into account obviously the upfront costs that we incur, but also then it includes our time an external resource that we've had to take on board, and then we've got a calculation that works out the outcome. So it's sort of, there is a standard model, but obviously it's applied to whatever the social dividend outcome is. So, for example, if it was for the training opportunities, it's the number of hours they've had, and then the outcome will potentially, if a resident or a tenant has been able to secure any full-time employment or a further training opportunity, or whether it's paid or not, that's all taken into account. But it is an in-house model rather than something we bought off the shelf.
Okay, thank you very much for that. A question here. I wonder whether perhaps Lisa or Ranjit might be able to help us with this one. There's a question here about sort of sustainability. As greenness options become cheaper through efficiency increases and older designs becoming obsolete and so on, can options be easily built into contracts, or is that going to be quite tricky to do? Lisa, perhaps I could go to you first on that one.
It would completely depend on the contract offering that was put forward in the first place. To look to then change an offering could invalidate the complete contract itself, because it could completely change the specification of the contract that was awarded in the first place. So it would be wholly dependent on the original contract. But if you're looking to garner more sustainability, I would be advising people to build that into their contract offering in the first instance anyway, so that they've got complete coverage going forward.
Okay, and Ranjit, have you done any thinking about this? Obviously, one of the you touched on social impact and sustainability and so on. Is this something that you've thought about?
Yeah, we have started thinking about this, and as I mentioned, we have a green team that has specialised on this and to provide us with the advice and recommendations as a team. But we at the moment, we haven't explored it with the existing frameworks that are out there. We do buy off frameworks as and when required. But in terms of going forward new contracts, we are looking at making sure that we can add the environmental aspects and sustainability aspect into it. It's slightly difficult when you're splitting it down into lots, because obviously then it's smaller contracts you're working with. But the overall sense is to make sure that we've got some incorporation in there.
Okay, thank you. Just to go back to one of the to the previous question, somebody asking how do we know if we qualify for the social options. Lisa, perhaps I could go back to you on that. You mentioned that when you were speaking earlier.
Yes, I did. Just let me grab my notes through so I can find the area that we mentioned it. That was regarding to the abolition of the Part A and Part B services, wasn't it?
Yes, it was. Yeah.
It's the sorry, me. The social and health services. So if you're looking at there is actually an addendum to the Public Contract Regulations Annex 14, which lists the variation of the CPV codes to determine whether it would be classed under the social and health services. So there is actually a listing that I could provide anybody that wanted to review the information so that they could know what quantifies and what doesn't, because there's a detailed listing available.
That would be fab. I don't know whether that's available on a web link, but if so, perhaps you could pop it into the question and answer box in answer to that question, and then when people download it, they'll have the link at their fingertips. Thank you very much for that. I just want to move on now to there was a question here about whether the requirement to consider lots will encourage or discourage the use of frameworks, and what the panel thinks about that. Justin, could I come to you first on that one?
Yeah, thanks, Emma. I think that the approach to lots means that there will be more use of frameworks. I think that the thrust of the directives and the regulations to encourage the use of lots, to encourage more SMEs in coming into various markets, means that providers, contracting authorities will need to work together in order to establish, well, what can we do collaboratively in order to showcase our expertise and our ability. One way to do that is to use lots a lot more, and to have frameworks where you have a number of players in the housing sector coming together to say, look, we need to work together to get the best range of options in order to have a pre-procured set of tools in our tool bag that we can go to. And I think that inevitably that will mean more options for SME providers and more options for us as contracting authorities to make use of them. So yeah, I do foresee more by way of lots.
Thank you. Lisa, what's your take on this?
I can't see it having an impact on the lots, because I think it will just make framework usage more flexible. The lots provide greater flexibility anyway, so I can't see it having any limitations on frameworks and the use of lots whatsoever. Okay,
interesting. Ranji, what do you think on this one?
Well, from our perspective, we would be looking at just lotting most of our contracts, to be fair, rather than looking back at the frameworks, because obviously as a part of our mission of enhancing life chances, we want to make sure we're getting our local providers and suppliers involved. So I'm not sure that would be applicable for us. It wouldn't be that effective.
Okay. Lovely, thank you very much. I want to move next to a question here. How will aggregation rules work for calculating the threshold applicability conditions? Is that by legal entity? Justin, perhaps this is one for you.
Yeah, thanks, Emma. Yes, I mean there's helpful guidance in terms of how the approach will work, published and available from the gov.uk website, which again I can provide a link to separately, so that will be there in the pack to follow up, and it addresses the question of separate operational units, etc. The key issue of aggregation remains the same, i.e. how do we determine how we go about choosing the right procurement route, and are we procuring for works or for services or supplies. Different thresholds apply to those different types of things that we buy as contracting authorities. So are we getting into the territory where the value of the contract means that we need to trigger a full procurement? That's the background. And aggregation is all about, well, actually, are we buying one or two of these things separately, or three or four of them separately, or actually is the purpose behind it all to get one big procurement because they're all linked? They're all linked, and if they're all linked, then that needs to be treated as one combined procurement, which then often will tip you over the threshold level and mean that, yes, even if you don't want to, you have to then actually put it out to full procurement that complies with EU rules, etc. And in the guidance from the government, in terms of how it sees working in terms of contracting authorities that are divided into separate operational units, so one entity but that has lots of separate legal entities within it. For example, housing association with a number of subsidiary legal entities and companies, etc. The guidance is that where an authority is divided into a number of those units, with each of them having an authority to decide independently whether to enter into procurement contracts, aggregation needs to be applied to each unit. So it looks like actually the overall purpose is something that needs to be considered, and the authority that as a whole must consider what it needs, and therefore you're looking at the underlying purpose, and therefore you're looking at a situation where probably, if you're having a debate internally about whether aggregation applies or not, then the thrust of the guidance from the government is that, yeah, you should be anticipating that aggregation will apply, therefore you will be running the procurement, full procurement process, and there are exceptions, and there are details in the directive and in the regulations about ways to get around that. But the rule of thumb is that it continues to be the case that you look at the underlying purpose for the organisation as a whole, but have a look at the exceptions that exist.
Thank you very much, Justin. I've got another question here which has come in. Is there any clarification on what tender documents need to be available when the contract notice is issued? This person saying, I'd heard that this may include specification documents. And a couple of other sort of related points. Somebody saying that they'd heard somebody from the Cabinet Office saying that the 3 years accounts requirement was being relaxed or removed from pre-qualifying requirements, and that Cabinet Office speaker also said that bidders would no longer be required to demonstrate previous experience relevant to the public sector. So I wonder whether the panel can shed any light on those points. Lisa, is this something that you're able to help with?
In relation to the tender documents, the general rule of thumb is that all the documents should be ready to go on contract notice publication. This would include the specification, the PQQ, the ITT, should that be subject to the procedure that was being undertaken. In relation to the relaxation of the 3 years accounts, I would query that really. There's relaxation in relation to, there is supposedly a European single procurement document coming out that would allow all tenderers to submit one piece of information, and that is used going forward, but it wouldn't necessarily relax requirements. It would just mean less documents being submitted. I'm sorry, Emma, what was the third element?
And the third element was this point about previous experience and bidders no longer being required to demonstrate experience relevant to public sector.
I believe that is being lessened, and it won't be such a hindrance for providers going forward. Yes.
Okay, thank you very much. Justin,
yeah,
do you want to come in on that as well?
Yep, I agree. And the good news is that particularly if you are in the process of procuring social specific services where the light touch regime applies. And if you're procuring something that is under £750,000, then you will have more flexibility regarding the tests and the pre-qualification regime that you apply, and subject to complying with the Cabinet Office requirements on that. But the way it's shaping up is that for those services that are under €750,000, there'll be more flexibility about how you go about choosing, and for those other services where you're not hitting the regime threshold for works or for supplies or for services, then also subject to complying with bits and pieces from the Cabinet Office, you have flexibility to determine how you want to go about running a PQQ exercise. And even, this is an interesting addition that's a positive, and even just directly approaching individual entities that you know that can do it without having to run a particular advert if you come under those thresholds. So that's an interesting option that has been written down and stated for us to follow up and to use, knowing that we are actually complying with the law on that point.
Lovely, thanks, Justin. Interesting. There's a next question refers to support for small and medium-sized enterprises. Do the team know of or believe that there'll be any formal support for SMEs in developing the necessary skills to participate in procurement events in the future? Reference here to Business Link doing something of that sort back in 2009, but there not being anything of that nature anymore. Ranjit, perhaps I could bring you in on this one. You've mentioned working with SMEs and made reference to that. I don't know whether you're aware of anything sort of nationally, but perhaps if not, you can give a bit of an insight into how you're sort of tackling this at Circle.
Yes. No, we're not aware of anything nationally happening on this. Yes, previously Business Link used to provide that support, but we're not aware of anything that they're doing. As I stated before, we are, as an organisation, looking quite indefinitely to look at setting up workshops for our suppliers to come and talk to us, and so we can help them with the necessary skills. So potentially we will be talking to them about general criteria that we look at. If once we standardise a PQQ, possibly talking to them about a PQQ and how that's completed in terms of in terms of what input we need from them. But also on a wider note, we're looking to work with our peers in the sector, so that may possibly we can come together and organise something together on a bit of a larger basis, so that we can capture more suppliers out there and help them and give them top tips, and advise them on the best way to tackle opportunities depending on the size of their own organisation and also the type of contract that they're looking to tender for. So yes, and this is definitely something on the top of our agenda that we're looking to do.
Thank you very much, Ranjit. So there you go. Get in contact with Ranjit if you might be interested in collaborating on something there. Okay. Lisa, do you have anything to add on that one?
It will be difficult from a perspective of a contracting authority, for the fact that we cover 850 members at the moment. We would potentially be looking to run workshops ourselves for something of this nature to help guide them and help how to determine for them to access frameworks more easily. So yes, from a contracting authority, it is something that we would need to take the mantle on to help the SMEs out there.
Thank you. And actually, an additional point that's just been submitted, which is related to that, Cabinet Office has a stated target of 25% of spend with SMEs. Any sort of thoughts on that? And related to that, any thoughts on increasing diversity across SMEs? Lisa, since you've got the mic, perhaps you could continue with some thoughts on that.
The way that it would be undertaken from ourselves, we would be very member-driven. So we would look to determine how the members would like us to contract on their behalf, what frameworks they would be looking at, and then how we could work with members to work with their local suppliers and diversify in that range to help target the 25% of the spend.
Yeah. And 25% realistic or feasible, do you think?
It's a very large target, it really is. I don't know how feasible that would be, given that what would be the timescales to deliver that, because to state that there's a target of 25% and to do that in 12 to 18 months is asking a lot. You'd be looking at a long-range target to try to deliver 25% of spend to all SMEs.
Yeah, absolutely. Ranjit, do you have a take on this? Do you have a sort of a number in mind?
No, agreed, Lisa. It is a very large target, but as an organisation, we will obviously try and do as much as we possibly can. We are sort of driven as well with in terms of our registered providers, in terms of what they want and what areas they cover, and the local providers that are available there. We do try and do as much as possible locally, but obviously there are areas where we have to look at it as, from a group-wide view. So it's going to be a balance, but as Lisa has already said, we need to have an idea of timescales so that then we can then form a strategy to try and reach that and deliver upon that target.
Yeah. Thank you very much. I'm afraid that that our hour is almost up, so it's time to draw the session to a close there. But I think we've covered quite a lot of ground and a variety of different angles on this. So I hope that everybody has found it useful and interesting. I'd like to say a big thank you to our panel, Justin Alford, Ranjit Kaur, and Lisa Hewitt, and thanks also to the audience for your participation and for your questions as well. A reminder that you'll be able to download the presentations and a transcript of the answers given in the Q&A box probably early next week on the Inside Housing website, and you'll also be able to watch again if you wish, or indeed to forward it on to colleagues who might be interested. You'll be able to find the recording at insidehousing.co.uk/events/webinars. Those of you who are watching live now will receive a feedback form. We'd be very grateful indeed if you would complete that. It really helps us to shape future webinars. So thanks again to everybody. We'll be back again in January with some more topics, but until then, it's goodbye from us. Thank you very much.